Hi, good morning or good afternoon. I just wanted to start by welcoming you all to today's webinar. We did say that we would start at 10 o'clock, and some people are still logging in. So we're going to wait another 3 or 4, 5 minutes just to give everyone an opportunity to get logged in and settle down. And welcome. Good morning, everyone, or good afternoon. I just wanted to assure you that we're still here. We have a few people who are still joining the webinar, so we're just going to wait 1 to 2 more minutes, and then we're going to get started. So thank you for joining us, and thank you for your patience, and we'll get started in another 1 to 2 minutes. Good morning, everyone, or good afternoon, depending what part of the country you might be joining us from. I first want to say I hope you're all well, healthy, safe, and taking good care of yourselves. Today's webinar is how to advocate for insurance coverage for eating disorder treatment. And this is part 1 of the 2-part webinar. My name is Carrie Schwartz, and I'm a senior attorney at Kantor Kantor, and I'm also presenting this webinar today with my colleague, Elizabeth Green. And I just wanted to start by telling you a little bit about myself, and Elizabeth will introduce herself in a moment. I've been at Kantor Kantor since 2014. Prior to coming to Kantor Kantor, I was a disability attorney and advocate representing individuals before the Social Security Administration to get disability benefits. And in that work, I represented thousands of claimants across the country, getting Social Security disability income benefits and Social Security income benefits. And since coming to Kantor Kantor in 2014, I'm able to work with individuals across the country who have individual healthcare policies and try to get them health coverage or health benefits that have been denied by insurance companies. My work focuses on individuals who are not covered by ERISA, which is something that we're going to delve into and talk about today. And I do work across the country, and I work with local counsel in other states and other jurisdictions. And in my time at Kantor Kantor and in the work I've done, I've developed a special focus or niche in the area of mental health treatment and eating disorder treatment. So that's what it gets me up and motivated every day to help my clients and continue doing the good work we do and the fight that we're in. So with that, I'm going to turn it over to my colleague, Elizabeth, so that she can introduce herself.
Hey, everybody. It's great to be able to do this. We get a lot of questions, and it's really great to be able to address all the new things that are happening too in a way that reaches a lot of different people. I am Elizabeth. I've been at Kantor Kantor for about 15 years. I've been practicing law for about 20, a little more than 20. And I've been doing this specific work in these ERISA claims for a long time. It really is a really satisfying job to be able to get benefits for our clients. These mental illness claims are particularly challenging because of the stigma that's attached to them, which is a lot different than our regular health claims. So I think that we're happy to give them more attention that they deserve and really help this community. So we're excited to do this webinar. We hope it's really helpful to you. And we offer you to answer any of your questions. She mentioned that too. So there's, these Zoom features have chat feature. Feel free to ask questions. We have loads of time today. We won't be talking for a full hour. And we want to make sure that we answer any individual questions you might have. And you can always reach us after as well. I'm going to turn it back over to Carrie, and she'll give you some more information, but we'll have our contact information too. Feel free to contact us with specific questions.
So as Elizabeth said, we do have a chat feature in the webinar. So please feel free throughout to enter your questions. We might not stop right away to answer them because it's a lot happening in front of us at the moment, but we will definitely, as Elizabeth said, leave time and have time at the end, and we will make sure that we go back to the chat feature and address any and all questions. And we'll say this again at the end, but I'll just get it out there now because a lot of people like to know. We will send you a link after this webinar, probably tomorrow or Monday, so you will have access to our slides and our presentations. So if you want to go back and reference them at any point, you'll be able to do that. And if you want to share it, you're welcome to do that as well. So a little bit about who we are and what we do. We are attorneys at a law firm called Kantor Kantor. There are approximately 18 lawyers in our firm. Our main offices are in Southern California. We do have some offices in Northern California. We have an attorney who has an office in San Diego, another attorney in the Washington State area. So we represent claimants who are seeking to recover health, disability, and life insurance benefits. We are a contingency law firm, and this is often one of those awkward conversations that people have to have with an attorney. So we just like to get it out of the way. So if anyone wonders, and what does that mean? What does that mean? It means that we do not take a fee upfront from our clients, and we only get paid if we are successful in resolving the case, whether it be through a settlement or through a decision by a judge. But in the event that we are not successful, which isn't very often, but if it does happen, our clients are not responsible for our fees and they don't have to pay us. So it really is a win-win situation for people to contact us and reach out to us, because we don't charge to talk to them, to consult with them. And if we decide to take the case, we don't ask for any money up front. We handle cases such as administrative appeals and litigation all across the country. We have cases right now in California, Texas, New York, Florida, Illinois, Arizona, Washington. This also means that we have developed great relationships and rapport with other attorneys in other states who might not specialize in this area, because we are the only law firm in the nation that focuses on mental illness and eating disorder claims. But we work with other attorneys in other states who are equally passionate and interested about the work we're doing, and they want to help the families and the individuals that we're representing. We also collaborate with leaders in the field of eating disorder treatment so that we can learn about the legal needs that are particular to this community, so that we can best serve patients, and also learn from the treatment providers and what they're dealing with day to day, as they're also trying to battle with insurance companies and not lose sight of the treatment that they're trying to provide to individuals who are in their facilities or in their care. Another part of what we do is educating patients and families about their legal rights to health benefits. And I think this is something that both Elizabeth and I really enjoy doing. We love connecting with people in the community so that we can share this information and this knowledge, because while we're out there doing it every day, we recognize that this is very daunting, it's very confusing, and very frustrating. So we want to try help as many people as possible navigate through this complicated, crazy system of health insurance for eating disorder treatment. So this is a little bit about kind of what sums up how most people feel when it comes to getting benefits paid for any type of insurance, but especially when it comes to mental health benefits for eating disorder treatment. It's all very confusing, and there never seems to be an end. And you might start somewhere and feel like every time you move an inch forward, you move a foot backwards. But rest assured, we have a roadmap for today to try and help alleviate some of that confusion. And we're going to talk about the different types of health benefits coverage that are available. We're going to talk about critical language to look for in insurance policies or benefit plans. We're going to talk about medical necessity guidelines, what they are and how they apply to your claim. And as we said before, we're here to answer your questions. So please feel free to use the chat box. And if for any reason, as Elizabeth said, you have additional questions that come up after today, you will have our contact information, and you can reach out to us individually with additional questions that you leave with. And also, there will be a part 2. So some of your questions might also be answered if you come back for part 2.
So we're going to start at the beginning, which is, what kind of health coverage do you have? This sometimes gets ignored, I think, but it's really important. Knowledge is power. I'll probably say that 10 times today, but the more you know about your health coverage, the better chance you have of getting your claims paid. So to start with that, you need to know first, do you have an ERISA plan? Do you have not an ERISA plan? Those are sort of your two options. I'm generalizing a bit. There's a lot more that goes into it. We'll talk about a lot of it today. But generally, ERISA, it's a acronym for the Employee Retirement Income Security Act. It's a federal law, and that governs all benefits that are provided by an employer. There are a couple exceptions, but generally, this is how most people get their coverage for any healthcare. It can either be self-funded by an employer, or it can be through an insurance policy. And then the other type is not ERISA. So it's anything from purchasing an individual policy on your own. You might go and get an ACA policy maybe. Or if it's through, I said there are a couple exceptions to ERISA, and those are if you're working for a government employer, which could be even like a school district sometimes, or a religious employer. And that could, it's not necessarily just a church or a synagogue, it could be a Catholic hospital. That could be a religious employer too. So those are the two different types. And we go to the next slide. I'm going to talk to you first about ERISA. I just want everybody to know that this law applies. It's going to apply to most of your claims. And these are the rules that everyone is supposed to live by. And by knowing what these rules are, you've got a better chance of fighting back. So want to give you as much information as you can take in on this. We're going to try to keep it simple. As I said, the coverage is through an employer. Even if you paid some of your premium, it's still covered under ERISA. There's the full name for you. You can request a copy of your benefit plan from HR. This is true regardless of if you have a government employer or a religious employer. You can always request it from HR. And I didn't put this in the slide, but if you're going to write one thing down today, I would write down that if you have an ERISA plan and you request your plan, you write to what's called the plan administrator, which could be just Dear Plan Administrator and the name of the company, and you put it in writing, I want a copy of my plan, my health plan, and all plan documents. They have to give it to you within 30 days under this law, ERISA, and if they don't, there's a penalty of $110 per day. So it's something I try to do at the beginning of every case, not just because, you know, it's some extra benefits, penalties that my client could get, but it's just good practice. I mean, they have to get in the custom of giving the plan document to employees when they ask for it. So we're going to talk a lot about the benefit plan, and if you don't have it, then you're kind of at a loss for what it actually provides. So the other things that ERISA gives you, if a claim is denied, you have to appeal before you can file a lawsuit. This is something that there's very little wiggle room for. If you miss it by a day, you have missed it, and you have to exhaust before you can file a lawsuit. There are no jury trials. The idea is that ERISA is very streamlined. The Congress, when it enacted ERISA, thought, well, if we put too many penalties on employers, they're not going to provide these benefits, and these are how most employees get benefits. So we're not going to burden them with a jury trial. We'll keep a bench trial. Also, because it's a federal act, it has to go through federal court, and that means the federal judges, who are appointed by the president, whatever president was that appointed them at the time, makes the decisions on these cases. So it's very important to me to know, it's kind of the most critical thing in a case, who the judge is, because it's entirely within the judge's hands as to what happens to the case. And then again, because Congress wanted to not give too many penalties to the employers, the remedies, if you win at trial, are limited to just the benefits that you should have gotten in the first place. If the insurance had done everything right, what should you have gotten in terms of benefits? And you can get your attorney's fees and costs paid for. So that's nice, because the idea is that you get made whole. There are, though, no damages for emotional distress. I know a lot of our clients have hassles of travel and related to the denial or costs involved. None of that is recoverable under an ERISA case. It's just the attorney's fees and costs and the benefits. And now Kara's going to explain the other cases that fall under the non-ERISA coverage.
So as Elizabeth mentioned earlier, a non-ERISA or individual insurance plan is something not covered by ERISA. And this could be a policy issued through a government entity or a religious employer. It could be a school district. It could be someone who works for the federal government. Or it could be an insurance policy that you or someone you know purchased privately through an insurance agent or through an exchange, and you are paying the premium when you purchase an insurance policy privately. You always can request a copy of the policy from your insurance company or from the employer. You have a right to that, and oftentimes you'll find that you might have access to a portal through your employer or through your insurance company, and you can always start there and see if you can download and print out a copy of the policy there. The key features of these individual or non-ERISA insurance policies are that there are jury trials. So we are allowed to go before a judge. We are allowed to have a jury. We are allowed to bring in evidence outside of the administrative record. An example would be the testimony of a treating provider or an expert witness, or in fact, the testimony of the patient, if they're able to testify and speak to what happened while they were in treatment, and if they have knowledge about what happened with the insurance company. Remedies in these non-ERISA cases can include not only the benefits that were paid, but it can in some cases also include emotional distress damages, attorney's fees, and punitive damages. But this all depends on the state law and whether the employer plan was insured. Something else that we also look to are whether or not there are bad faith remedies depending on state law. So one of the things that Elizabeth and I often talk about is, in some respects, her job might appear easier on paper because everything is streamlined and regulated by ERISA. It nonetheless is still frustrating, confusing, and difficult. And my work can be a little more complicated and complex because we are always having to pay attention to the rules and laws in every state and every jurisdiction that we go to. There is no one streamlined process for these types of cases. So just to recap, we've talked about the two different types of insurance, ERISA and individual, and we now have an idea of what they look like and how to compare them. So again, ERISA benefits are obtained by an employer that is not a government or religious organization. ERISA benefits, you can get the plan or policy by asking the Human Resources Department. In ERISA cases, there are no jury trials. The case is decided by a federal judge. An ERISA claim, there are no punitive damages, and the trial is limited to documents that have been generated during the claims and appeals process, which is often referred to as the AR or administrative record. And in a non-ERISA case, the plan or policy is obtained by a government or religious employer. Those are the ERISA exceptions. Or it can be an individual policy purchased through an insurance company. You can get a copy of your plan or policy by asking your insurance company or your employer, or again, as I said, perhaps even looking online on a portal to see if you can access it there. In non-ERISA cases, we do have jury trials. There are other damages available besides just the cost of the treatment. So sometimes we might be able to get punitive damages. And in a non-ERISA trial, we are able to bring in witness testimony, expert documents. We can go outside of what is known as the administrative record.
So let's get into the ERISA regulations. I worked very hard to narrow this down to 3 slides of substance because it is very convoluted. It can be confusing, but it's not much use to you if you can't understand it. So I want you to know what is supposed to happen. This is what's supposed to happen for an ERISA case. These regulations are set up so that you're protected, the claimant. So how you can go forward with your claims and your appeals, it really depends on what your rights are. I kind of like this slide. The analogous for me is you know, your insurance really for an eating disorder claim, whatever level of your care you're at, they'll only cover the level of care below that. So that seems to be what our clients are routinely facing. It's always something not what they're getting, which is what the insurance says they need. So the code, this is a code section on the slide where the CFR, that particular site, if you ever want to put that in a letter to reference ERISA and show that you know what you're talking about, that's what you're going to put in there. ERISA is supposed to help you. This is set up to help employees. It's the Employee Retirement Security Act, not employer. And we often remind ourselves of that. It's supposed to help you by making sure that everything's in writing. The claims, the denials, the procedures, everything's supposed to be in writing. And an EOB, an explanation of benefits that you might get, can be a denial. So it might trip you up, but if you get an EOB and there's a little footnote and they're not paying the claim and the footnote says not a covered benefit or not medically necessary, that's a denial and you got to appeal it. The other thing we hear a lot from clients is, I can't get it in writing. I can't get the denial in writing. They just won't give it to me. You have to be able to get it in writing. I mean, basically our response to that is do what you can. Be a big bee in their bonnet, write, call over and over until they send you a copy in writing. They have to send it to you in writing. They cannot require more than 2 appeals. So sometimes you might see an external review. Maybe the plan has 2 appeals and then there's an external review. That's another option. You don't have to do the external review. It might say something like you're going to lose rights if you don't do it. You don't have to do it if you already did 2 appeals. The initial appeal cannot be due before 180 days from when you got the denial. So if you get a denial, you can calculate from the day you get the denial, 180 days, that's when your appeal is due. But you do want to maybe give yourself a few days. Don't make it real tight, because I said if you miss that deadline, you're out of luck. And if there isn't a second appeal that's offered, it doesn't have to be offered, but if there is a second appeal offered, it doesn't have to be 180 days. It can be as short as 60 days. So it's a real quick turnaround. I know sometimes these letters don't arrive, you know, it's mailed on the 1st, you don't get it until the 15th, you already lost 15 days of the 60. So you have to be quick with that. ERISA provides that an expedited appeal, which could be if someone's in residential treatment or inpatient treatment and you need a quick decision on this, you know, they're in treatment right now. Those are usually decided on an expedited basis, and that would have to be a decision that's given to you within 72 hours. Providers know this. Providers are keyed in. It's quick. We got to have somebody on the phone within the next day or so for review. So you should know that that's an available option as well. And a concurrent request would be if somebody's in treatment and it's an ongoing treatment. So it's concurrent. And you're asking for the same level of care they're already getting. That has to be decided before the approval period ends. So if they've approved through Saturday, they need to tell you by Friday before Saturday ends whether they're going to continue paying or not. So that's what's supposed to happen. Let's see the next slide. So you have an initial denial and appeal I talked about. These are supposed to be in writing, and these are supposed to be what they look like. They're supposed to give you, for the initial denial, so I'm looking at the left-hand column of this slide, a specific reason for a denial. We're going to talk on the next slide about an example of what a court saw that wasn't specific enough. They're supposed to give you a specific reference to a plan provision. So if they're denying on medical necessity, they should tell you what that plan provision says. It's not medically necessary because the plan requires XYZ. They should tell you what, this is probably one of the ones we never see actually happen in practice, but they're supposed to tell you what you can do to perfect your claim. So no, your claim's not being paid, but what could you do to make it so it will get paid? Maybe there's some treatment records that could be submitted. What are they missing? Sometimes they're, oh, we don't have information on that, or we didn't have the right billing code, whatever it is. They should tell you what you can do to perfect the claim. the goal is to have good communication here. So, you know, if it's something, it's not hide the ball. If there's something that you can do to make it better, they should tell you. They have to tell you how to appeal. Where do we send an appeal to? What's the time frame to appeal? Don't get tricked up on this though. Sometimes the letter, the denial letter, may have a different address or a different time frame than the plan document you're looking at. We always go off the plan or whatever the shorter time frame is. You don't want to be stuck and not getting it done on time. So go with whatever's most conservative there. They have to provide guidelines that they rely on. I'm sure a lot of people listening have heard about like Anthem's guidelines or UBH level care guidelines. Carrie's going to address these a little bit more, but you're entitled to get those as well. And again, going over if it's a medical necessity determination, they have to explain what it is or offer it to you. So the denial offers slightly different things because now they've already looked at it once, they're looking at it again. So the right-hand column of the slide, we have the appeal denials. They have to give you a full and fair review, which means that everything that you sent in on the appeal, maybe you just sent a letter, maybe you sent a bunch of treatment records and a great provider letter or many provider letters. They need to give that a fair and full review. Look at everything and look at it fairly. I'm going to give you an example of that on the next slide of what a court did with that. They can't defer to the original decision. This is up to some debate. Often we see a rubber stamping sort of the first decision. Maybe it's verbatim repeated in the appeal decision. I think that's a little crappy. They should probably put some independent thought into it. But the idea is they're not supposed to just look at that first decision and then do it again. It's kind of a fine line. It can't be decided by the same person as the first decision. So say you have Smith decides the initial denial, Dr. Smith, you can't have Dr. Smith deciding the appeal denial. It needs to be a new person. And that person, whoever they're consulting with, if it's a medical necessity denial, it needs to be, and this is tricky language, a healthcare professional with appropriate training and experience. Well, a healthcare professional could be a nurse. And for eating disorder claims, we make a big stink about a lot of these reviewers don't have any eating disorder treatment experience. They're paid reviewers. Maybe they're psychiatrists. Maybe they went through some training in their residency through a psych unit where they treated some eating disorder patients. But I'm not sure that that makes them qualified to be giving an opinion on someone that they've never met. So that's an issue we have to, but they're supposed to, that's what they're supposed to do, healthcare professional with appropriate training and experience. And then they're supposed to identify who the medical reviewers were. So you can look them up, see who they were. It shouldn't be a hide the ball. And let's move to the next slide and I'll give you some of these examples. So I wanted you to see how this kind of plays out. The courts tend to set a low bar for these procedural errors. They don't want to decide cases on a technicality. They didn't give you your appeal rights in the letter. All right, did you end up appealing? Fine. You know, they tend to not want to nitpick, but sometimes they do get held accountable. And these are cases that we've had that have been really successful, but it's unusual sometimes to see this. I feel like it should be the norm, but so for the first bullet point, no specific reason is given. So I love this, that the denial simply says that care could have occurred without outpatient providers. Well, why? Well, there's nothing in this letter that tells me why. And the court understands that. The court says this isn't meaningful dialogue that is required by ERISA. They need to provide a comprehensible explanation for denying the claim. So the court got really stuck on that, which I was all for. And the next bullet point, no full and fair review. I'm going to give you two examples of how this plays out. Both are completely contrary to one another, and this is why the courts are what they are. They interpret the law, and sometimes when they apply it to facts, courts will decide differently. So the first example here, we have a letter from a treating physician which provided specific reasons why residential treatment was medically necessary. Some of these might seem familiar to you. that the patient required monitoring during and after meals, monitoring of exercise, a blind weigh-in, and the court faulted UBH for never saying why this is insufficient to support the claim. You know, the court's saying you have to address this, you have to give a full and fair review and explain why is this letter no good. I loved it. It's great. It's exactly what we are looking for. And then under that, I'm citing to a case that just came out, just reviewed it for a newsletter that our firm does on ERISA cases. And it was really disheartening. You know, this is a district court in Kansas who said, you know, they can take them into account, but they don't have to address it. Well, what's the difference? How, you know, it boggles my mind, but you can see how two courts see something very differently here happening. And then the final bullet point is really about identifying the medical reviewer. The court found that by not identifying the reviewing physician, it added to the procedural errors. And a lot of this is the court is thinking, if there's already reasons that the denial doesn't pass the smell test, then the court is going to hop on board. Well, not only do the facts not really seem like they support the insurance company's decision, but now we have all these procedural errors too. Like it increases the skepticism that the court's going to give to the insurance company's claims. So Carrie's going to take it from here. We're going to talk about what we look for when we're reading over plans.
So as you can imagine, because we're the only law firm in the country that focuses on mental illness, litigation, and treatment for eating disorders, we receive calls all the time from all over the country with people with all different plans and all different language. And the first thing we always ask everyone is, do you have a copy of your plan or your policy? We're not going to get very far in having a conversation with you or helping you if you can't provide that to us. So I know this is all very basic and rudimentary, but these are the nuts and bolts of what we go through every day when we're reviewing and analyzing different cases. So people ask us, what is it that you're looking for? And what are you doing when you're looking at our plans or our policies? Or conversely, what should we be looking for? So we want to help you understand some of these key terms and some of the terminology that is important to identify and define and to understand. And if you can't understand it, then that's when you need to start asking questions and make sure you can. So sometimes in a plan, you'll see something that's referred to in the first bullet point as a pre-certification penalty. So pre-certification penalty can be used if you have not asked for pre-certification before admission to treatment. So an example of a pre-certification penalty from an Aetna policy here says a pre-certification benefit reduction will be applied to the benefits paid if you fail to obtain a required pre-certification prior to incurring medical expenses. This means Aetna will reduce the amount paid towards your coverage, or your expenses may not be covered. In our experience, how is this going to be interpreted? Most courts will say that if you did not get pre-certification, Aetna does not have to pay for the medical expenses that you incurred. There are other policies that will have a pre-certification penalty with language that will specifically say, for example, there will be a $500 penalty if you do not obtain the required pre-certification prior to incurring medical expenses. So these are just some examples, again, of one of the plan terms that we want people to be aware of and to be cognizant about before you are put in a situation where you're going to be held responsible for medical expenses. The second bullet point, another plan term that we wanted to talk about, is what's referred to as proof of loss. Proof of loss or submission of claims. So a plan, a policy might state that you have a deadline to submit claims, and this can be especially important for out-of-network claims that you may have to submit on your own. So here's another example from a policy that we looked at. All claim forms for non-network services must be submitted within 12 months after the date of service. Otherwise, the plan will not pay any benefits for that eligible expense, or benefits will be reduced as determined by United Healthcare. This 12-month requirement does not apply if you are legally incapacitated. If your claim relates to an inpatient stay, the date of service is the date your inpatient stay ends. This is important. It's important to know that once you start treatment, your proof of loss and this timeline starts, it kicks in. So the clock starts rolling. And if you plan to submit claims, you have to be mindful of these different dates that are going to apply and what the deadlines are, because these plan terms are going to be interpreted very strictly. Statute of limitations, the third bullet point. The statute of limitations is the time in which you have to file or commence a lawsuit. So it is a very important deadline. It can allow, if you're within the statute, you can file the action. If you're beyond the statute, you are now barred. You cannot file a lawsuit. One example from a policy is no such action shall be brought after the expiration of 3 years after the time written proof of loss is required to be furnished. So here we have an example of a specific statute that's stated in a plan. And what if your plan doesn't state anything specifically? Well, if your plan does not state anything specifically, then we always defer in both the ERISA cases and the non-ERISA cases to what the state law says regarding the statute of limitations for bringing a cause of action for breach of contract. So for example, in California, the law says that you have a statute of 4 years to bring a lawsuit. We've seen policies that could have statutes that range for as little time as 1 year or 2 years to as many as 5, 6, or 7 years. So while there is no one answer to this question, what is my statute? We will always start with what does it say in your plan or your policy, and then we will go from there. Something else that you'll find in your plan is the number of appeals that you are allowed to file and the time frame in which you have to submit your appeals. And as Elizabeth said before, the timelines can be as many as 180 days for your first appeal to as short as 60 days for your second level or your appeal denial. So keeping track of where you're at in the process and when the clock starts ticking and what your deadlines are is an extremely vital and crucial part of this whole process and getting through this game and this web of appeals and denials.
So a few more plan terms, and I just want to address a question that's probably going to come up that we often hear with pre-certification, to just jump to the back to that for a second. You might not get pre-certification granted. It's not the granting of a pre-cert that you want, it's the asking. You have to show that you asked for it. So it's sort of a misnomer because, yeah, they're probably not going to pre-cert it, but at least you asked. So you have satisfied, you can put a check on that one if you at least call or write, whatever you need to do. Okay, so last slide of plan terms, wanted to go over a residential treatment center definition. This was taken from a plan that actually has, I mean, I gave you 4 bullet points here. It probably had 20 little requirements, individual requirements for a residential treatment center. That's sort of one end of the spectrum. And then there's a plan that doesn't even define a residential treatment center. But if it's defined, or if it's like a partial hospitalization program is defined, you need to know that, because if you're trying to get into that level of care, you want to know that the treatment center that you're picking, that you're going to go to, actually satisfies the plan. So this, requires that you're admitted by a physician. You can see the items here. The wilderness treatment program, that's also a really hot topic. And sometimes they're outright excluded. Sometimes there's no mention. Sometimes it falls under residential treatment. It just depends on the plan. So exclusions are also something we are really passionate about. We've done a lot of cases on mental health parity, particularly in California, but also federal mental health parity, which does require treatment for residential treatment for mental illness if mental benefits are applied. So if your plan doesn't provide any mental health benefits, then you can't ask them to provide for residential treatment. But if you have a plan that provides for mental health benefits, then they can't exclude residential treatment. And here's a pitch for, I'm developing cases on denials of nutritional counseling for eating disorder patients. So that is really interesting to me because a lot of plans will pay for nutritional counseling for, say, diabetes or high blood pressure. Usually it's diabetes. They have a separate little provision, like we'll do educational nutritional counseling for you if you have diabetes, but then they deny the eating disorder claims. And that seems like a parity violation because they have to provide the same thing for mental health claims that they do for a physical illness. So look for those exclusions. A binding arbitration. So what this term means is arbitration is a way to resolve something. It's more informal than you would be in court. You would probably have a retired judge or an attorney serve as an arbitrator. Binding means that it's whatever that arbitrator says after hearing both sides is what you have to do. So you're stuck with whatever the decision is from binding arbitration. You don't go to court. This doesn't apply to ERISA plans. ERISA, you go to federal court. So often these binding arbitration provisions are still in another plan that's an ERISA plan. They kind of just put it in. It's a generic language. Sometimes it gets thrown in, but you can ignore it if you have an ERISA plan. If you don't have an ERISA plan, you may see language like this, and you are subject to binding arbitration. And then the big whopper for us is the medical necessity definition. I mean, this is how most claims get denied. And it often includes language like, treatment is medically necessary if it's within the generally accepted standards of medical care, which we know from some recent great case law that one of the ways to determine what generally accepted standards of medical care are the APA guidelines, the American Psychiatric Association guidelines, which there are for treatment of eating disorders. So that's kind of our gold standard that we turn to, and courts are starting to turn that way as well. Insurance companies are not so quick to do that. So Carrie's going to talk now about what the medical necessity guidelines are that the insurance companies are using. And they kind of weave this in their own way into that medical necessity definition. So you need to know what the plan requires, but you also need to know, besides the plan, what is the insurance company doing? How are they determining medical necessity?
So, in every plan, we see something to the effect of benefits are provided only for services that are medically necessary. And then where it gets a little different to some extent, but not always, is how that plan or policy defines what medically necessary means to them. So when we litigate cases, we have to make sure that we know and understand that what that language is from that plan or policy so that we know what we're up against, because every insurance company is using different definitions. So here's one example from a Blue Shield policy that I'm actively litigating. And the language says that services that are medically necessary include only those which have been established as safe and effective, are furnished under generally accepted professional standards to treat illness, injury, or medical condition, and which, as determined by Blue Shield, this is the sticking point here. Blue Shield gets to determine if they are consistent with, guess what? Blue Shield's medical policy, consistent with the symptoms or diagnosis, not furnished primarily for the convenience of the patient, the attending physician or other provider, and furnished at the most appropriate level, which can be provided safely and effectively to the patient. So working from the bottom up, furnished at the most appropriate level, Elizabeth already alluded to this, no matter what level of care you're at, they're always gonna believe that the most appropriate level of care is 1 or 2 levels below where you're at. So most commonly, the majority of our cases have to do with individuals who are receiving residential treatment, and the insurance company always shockingly believes that partial hospitalization would be the more appropriate level of care. In fewer cases, they might say IOP or intensive outpatient care, but majority of cases I would bet on are going to tell you that partial hospitalization would be appropriate placement for someone who's in residential treatment. So that's one sticking point that we often look at. And consistent with Blue Shield medical policy, this is interesting. So who gets to set the definition? Well, the insurance company gets to set and create their own definition, and they get to create their own medical policy. So what are these policies and guidelines? Shockingly, insurers have developed medical policies that serve as one of the sets of guidelines for their medical coverage decisions. And as we discussed earlier, this should be stated or referenced in any denial letter. You have to know what they are using as the basis of their denial. So if they are using their own medical policy or their own guidelines, they have to tell you that. And they also have to provide or make available to you a copy of those policies or guidelines. If the guidelines are not referenced in your policy, you may need to ask for them. So it's okay to let them know you referenced a policy in, or guideline and you haven't provided it to me. And you could write them and ask for it in writing. You can call them and ask for it, but you have a right to obtain a copy of that. Sometimes the guidelines will be available on an insurance company's website. My only caution is to make sure that if you do find them on the insurance company's website, that they are the most current and up-to-date version of those guidelines. They always have an effective date on them, so you just want to make sure that you're looking at the same set of guidelines that the insurance company is also looking at and using in deciding or evaluating your case. So what are these policies or guidelines for eating disorder treatment? Well, we often see that Anthem has a clinical guideline for feeding and eating disorder treatment. Blue Shield has adopted Magellan Care Guidelines for behavioral health and eating disorders. Cigna has standards and guidelines or medical necessity criteria for treatment of mental health and substance use disorders. And the list goes on and on. The point being that every insurance company out there is using some form or some set of medical guidelines or medical policies that they have adopted internally. And you as a consumer, as a patient, as an advocate, have a right to know what they're using, and you have a right to obtain a copy of them. Most insurance company guidelines will address acute inpatient eating disorder treatment, residential eating disorder treatment, partial hospitalization eating disorder treatment, and intensive outpatient eating disorder treatment. And typically, when the insurance company has adopted or set company guidelines, they set out a list or a checklist or bullet points for criteria that have to be met for each level of care. And within each level of care, they will distinguish and create different criteria depending on whether the person is being admitted to care. And then they will create and set forth another set of criteria for that same level of care for continued stay. So it could be that they have applied one criteria for admission, and then you will see that they've applied another criteria for continued stay. And it's important as well to make sure that they are telling you which guideline, which set of criteria they are using in making their decision. And it's not uncommon for us to see criteria that are 4, 5, 6 pages long, and you wonder, how is a person expected to meet every single one of these criteria to get into treatment or to stay in treatment? And these are among the types of cases that we often end up litigating.
So we're finishing up. I want to just remind you that this is the part one about sort of what the groundwork is, what the landscape is. And we have a part two that's coming. And we want to really talk there about how you can submit your claims and your appeals for the best chance of success. So we're going to do it in July. We'll let you know if you're participating in this and you got this link, you'll get an email with the part two. And like I said, it's going to talk about the going through and submitting claims, how to challenge an appeal, and the latest in mental health litigation. These appeals, I have some great examples of appeals that were real winners. It really changed the course of the litigation by submitting a great appeal. So I hope that you'll see us again for that. We have a couple questions, and a couple of them are easy to answer. I'll just get them out of the way real quick. So a state police officer would be a government employee. That was one question. Another is about the penalty for not providing the plan document. If you are given that penalty, it goes to whoever the employee is that requested it. So if Mary Smith asks for her plan document and it's not given within 30 days, for every day after the 30 days, she can ask for $110 per day. And it is discretionary, but the courts often give it. So it's worth asking for. And then the other question I want to get to was pre-certification and pre-authorization are sort of the same thing. There's no difference. It's just terminology that's being used there. The question, we should have addressed this up front about Medicare and Medicaid. We don't handle Medicare and Medicaid. I think Carrie can talk about this a little bit more. It doesn't fall under ERISA. It definitely is like a non-ERISA, but it's sort of separate own plan. It's just Medicare and Medicaid are very different.
Like the ERISA plans, Medicare and Medicaid are also governed by their own set of federal rules and regulations.
Yeah. Yeah, that's the issue with that. Let me see if there's one other question. I think that was it for the questions that we got there. We are just about at 11, but we're happy to hang out if anybody else has anything specific they want to ask. And yes, here's our contact information. Our new cases go through Tara, who's listed here. She's our intake coordinator for the health cases. And she's probably going to ask you for a lot of information before we can talk about it. But that's, Tara's a great person to start with, but feel free to just, email's a great way to contact Carrie and I if you have just a quick question or, want these slides or whatever, we're happy to help. So the person who asked about finding someone about Medicare, if you want to email Tara, she may have someone. I think we do have a list of attorneys that might handle Medicare. And if we do, she has that list because we do get this question. So I would shoot her an email, say you listened to the webinar and you want to know who might be able to help with a Medicare question. I don't know for sure that we can give you a name, but try it. Give it a go. Oh, the Affordable Care Act. Okay, somebody has a question about that. So the Affordable Care Act is just a way that you, it just is a way that people can get individual health coverage. And it provides us a bunch of other benefits. I mean, it's many things. But when we talk about the ACA or the Affordable Care Act, we're talking about an individual policy someone might have just bought. You know, if we just went out and bought ourselves a health policy, you bought yourself an individual non-ERISA health policy. And so that's something, Carrie, if you want to address it, that's something Carrie specializes in litigating those cases.
Yeah, same, you know, basic principles and elements all apply to everything that we've gone through today. It's an individual policy, and we're looking to see what the benefits are. I would be very careful. The one thing that we've noticed most routinely and the common thread is you want to make sure that you know whether or not there's out-of-state or the difference for out-of-state benefits and coverage, because chances are you're going to be very limited in terms of geography and where you get coverage for your care. But again, that could apply to any policy. So go back to the basics and making sure that you have your policy and that you have looked for some of the key terms and language in that policy. But there's nothing that prevents us from litigating or taking on ACA cases.
Yeah, that's a good point though. You got to know what you're buying. If you're getting it on your own, or if you're signing up with your employer, they give you these options, and sometimes it's really confusing, an EPO or a PPO or an HMO, and an HMO is always going to be the cheapest, and it always gives you the least amount of coverage. And yes, I would definitely do ACA over Medicaid. You're going to have much better options. But, you know, think about it. Like, do you want to be do you want to be limited to your HMO network? Is that something you're comfortable with? Eating disorder treatment it's different than other types of treatment, and a lot of people go out of state, and a lot of people end up going to out-of-network providers. And if that's what you're looking for, you got to know that the coverage is there. We have a lot of people, not a lot, we have some people who contact us who say, oh, but I really wanted to go to this facility, or I really wanted this therapist, or but they're not in network and I don't have an out-of-network benefit. Well, we can't really do anything with that. We are kind of stuck with what that plan is. So the ACA, the Affordable Care Act, has been in law for, 8 to 10 years now. I think that the highlights of the Affordable Care Act, which also has the acronym Obamacare, same thing, just people give it another name. The highlights for us are that it requires that dependents can stay on their parents' ERISA plan until they're 26. So for young people, that's great. It's hard to get a really good policy, insurance policy when you're young. And if someone is sick and needs good coverage, staying on your parents' plan is an awesome way to go. That is something that we really liked. It prevents any pre-existing conditions to be able to get a policy. You can go out to get a policy tomorrow and you're not dinged if you had a pre-existing condition. It also implements a lot of the mental health parity that we discussed a little bit. It's just a way for people to be able to get coverage. It's often exchange of insurance policies that compete for your business. It's kind of been a game changer for us, because previously we didn't really have a great option if people didn't have coverage, what they can do to go get some coverage. You know, it was like, well, probably going to need to get a job. You get a job at Starbucks, they've got coverage for their employees. I mean, but now you can go buy a policy. They're not always cheap, but at least you get some coverage there. Carrie, do you want to add to that?
Well, I would just say, someone asked, you know, would the ACA be better to choose over Medicaid? And the answer is always, it depends. You have to consider what type of coverage is important to you or your family members or your child, what your needs are, and what coverage is going to be most effective and provide you with the most amount of coverage under your plan for the type of care you need. And so with any plan, that it's always, you always want to scrutinize it and ask questions. You always, if you have options, look at all your options and make an informed decision or informed choice. But don't be afraid to ask questions, whether it's of your HR department or your insurance agent, whoever's helping you, your broker. But get the information you need up front, because oftentimes we find people purchase an individual policy only a couple months later to realize that that's not what they intended to get, and that's not the coverage they needed. So make an informed decision to the best of your ability. So it looks like we've answered all the questions that I saw up here for today. So I'm just going to kind of wrap us up here and thank you all very much for taking the time out of your busy, hectic, crazy lives right now to spend this hour with us. It really is our honor and our privilege to be able to speak with you and interact with you and share this information with you. We hope that you take one thing from it. If you do that, then we feel like it's been a success. We hope that you'll share and spread this information with other people, family members, work colleagues, friends, and you have our contact information. So we hope that you'll reach out to us or Tara with additional questions or concerns. And we hope that we'll see you back here in July for part 2 of this webinar. And if there's something that you think we should address in part 2 of the webinar, this is kind of our, where we're headed for part 2. But if you feel very passionately that there's something that we should add to that list, please, please, please reach out to Elizabeth or myself or to both of us and let us know. We're very open-minded individuals, and we really want to serve the community and help as much as possible. So anything that's on your mind or anything that you're struggling with and you feel other people could benefit from, please reach out to us and let us know. And I'm going to say thank you for attending and for being with us today, and I'll turn it over to Elizabeth.
Yeah, thank you so much. It's great. We love our work, so giving us a forum to talk about it to you all is really gratifying. So thank you. Tune in July for part 2. We will make it really practical and give you some examples of appeals and that kind of thing. So people tend to find that really helpful, and we've done it before. But thanks. We'll see you in July. Take care, everybody.